You're watching proceedings at the Supreme Court of Ghana. It's day two, or the second hearing of this petition filed by former flag bearer of the NDC, candidate going into the 2020 presidential elections, John Dramani Mahama. He's seeking, of course, to overturn that result, to get the court to order the Electoral Commission to organize a runoff between himself and Mr. Kufuor. As he argues through his lawyers, none of them secured 50% of the votes. So essentially what's been happening today, we've seen lead lawyer for John Dramani Mahama, Tsatsu Tsikata, argue out a motion for leave to serve interrogatories. Mr. Tsikata's plea was for the court to allow the petitioner to get answers bordering on how Jean Mensah, the Electoral Commission chairperson, arrived at the figures used in declaring Mr. Kufuor as president-elect. And we've seen quite a back and forth on this particular matter, as one of the 7 judges raised the issue of not personally addressing the issues to Jean Mensah, but rather asking Tsatsu Tsikata to say Electoral Commission chairperson. But as we've seen, the lead counsel for Mr. Mahama also argue it out that he is referring to Jean Mensah to be specific, since she declared the results of the presidential election, also the officer in charge for that particular presidential elections. And then we've seen, of course, the Electoral Commission's lawyer, Justin Amenuva, also opposed to the court granting leave to, as he insists, the answer is in the petitioner's own petition, and also saying that your responsibility is in the law. Essentially, the responsibility of the Electoral Commission is in those laws regulating public elections, and that they don't have to go back to it. Seeks to, and that Mr. Tsikata or John Mahama's lawyers are seeking to introduce new fact not contained in the original petition, citing the 2012 petition hearing to back this. But of course, Mr. Tsikata also came back on that. But before that, also lawyer for Mr. Kufuor, Akoto Ampao, also argued it out as an interested party in this case. The court allowed him to only make positions on matters of law, as he is not directly involved in this specific matter, but only as a person of interest in this case generally. So he sought to explain interrogatories and the fact that they must relate to the issues raised. Also insists that, you know, the matters being raised by Tsatsu Tsikata have all been answered. And that, you know, during cross-examination, Mr. Tsikata would get the opportunity to ask these questions. So essentially also opposed to the court granting leave, just as the Electoral Commission is also arguing out. But Mr. Tsikata comes back again to make a case for it. The court is on a short recess now. We will see if they're going to make a decision on this particular issue of interrogatories. But I'll take you through the 12 questions that Mr. Tsikata, if this leave is granted, would be seeking to ask specifically the Electoral Commission chairperson. Just going to go through some of the 12 questions that, you know, essentially they raise in this matter shortly. Of course, this is Joy News. We thank you for watching the second hearing of this 2020 election petition. The petitioner, of course, is John Dramani Mahama, who is seeking to annul the December 7, 2020 presidential election result as declared by the Electoral Commission chairperson, Madam Jean Mensah. Shortly, I'll be sharing with you some of the questions being raised in this, as we also get ready to raise our reporter who is in court, Joseph Akable, on this. In the meantime, keep watching. Of course, we'll bring you a lot more in the course of this hearing. Just in a moment, we will be back with the questions on the interrogatories. And it's still our coverage of the election 2020 petition hearing, which has been on for a while now. Court is on recess. They will be back to make a decision on this requests that's been made by John Dramani Mahama's lawyers for leave to serve interrogatories. So here are the questions contained in this proposed interrogatories. And if it is granted, then we will see the returning officer in the 2020 presidential elections, Jean Mensah, come up to answer these questions. Was there a practice in previous presidential elections in the Fourth Republic of collated figures on constituencies being received in the strong room at the headquarters of first respondent in the presence of agents of the candidates? One of 12 questions was the practice described in paragraph 1, which is question number 1, followed in respect of the 7 December 2020 elections. Is the 7 December 2020 presidential election the first time a regional collation center or centers have been interposed between constituency collation centers and the headquarters of first respondent? How were results transmitted from the constituency collation centers to the regional collation centers? How were results transmitted from the regional collation centers to the headquarters of the Electoral Commission? Did the National Communication Authority facilitate in any way the transmission of results to the headquarters of the Electoral Commission? When did Mrs. Jean Mensah, the chairperson of the first respondent and the returning officer for the presidential election, first realize there were errors in figures as she had announced in her declaration of December 9th, 2020? How did Mrs. Jean Mensah, the chairperson of the Electoral Commission and the returning officer of the presidential election, get to realize there were errors in figures she had announced in her December 9th declaration? In respect of the purported corrections made by the figures in the declaration by the Electoral Commission, was there any process of conferring with agents of the presidential candidates? So that's 9 out of the 12 questions. But as we have seen, there's actually a response from the Electoral Commission. I'm just going to pull that pretty shortly. Affidavit in opposition by the Electoral Commission to these 12 questions being posed by lawyers for John Dramani Mahama. Chikata said, from what has been revealed through Chachi Chikata, the Electoral Commission, and in this case, Jean Mensah, on the first 3 questions, says that they are irrelevant as they are not in accordance with the public election regulation. Okay. Chachi Chikata strongly disagreed with that as well. So essentially, Electoral Commission declining to answer the first 3 questions that you see in this as revealed by Chachi Chikata, saying that they are irrelevant, and Chachi Chikata disagreeing on question 4. Also, the Electoral Commission says that it is irrelevant. Question 4 and 5, and Chachi Chikata says that can hardly be irrelevant as they are critical to what was actually done in the election. Let's cross over and speak to Joseph Akable, my colleague who's in court for us this morning. Joseph Akable, you've been in that court. First of all, tell us who is in court today.
Hello.
Joseph Akable, if you can hear me, I'm asking who is present in court today.
So the main actors in this particular matter, starting from John Dramani Mahama, who brought this particular case to the Supreme Court, is present. Mr. Peter McMahon is representing the MPPs, Nana Akufo-Addo, whose election is the subject of this particular litigation here. And as you recounted, there are a series of questions that Mr. Chikata, who is representing John Dramani Mahama, they are asking that the Electoral Commission is directed to provide some answers. The point being made by the Commission is that such questions must relate to matters that are in dispute. And as far as they are concerned, the matters that are being requested of them are not in dispute. The other matters that are in dispute are issues of questions that are nowhere in the petition that Mr. Mahama has filed. And so they specifically make reference to a question about whether or not the NTA assisted in the transmission of results. And the point they make is that that particular issue is nowhere in any of the pleadings or the petition that has been filed by Mr. Mahama. So they do not understand why they are seeking to use the back door in this instance through interrogatories to ask those direct questions of the Electoral Commission, hoping that they answer them. And they believe that is a ploy to simply delay the court. And so they are asking that the court should not allow that to happen. The same point was canvassed by Mr. Akutuampao, who represents the president's legal team, and he was allowed to speak on a point of law, and he again made reference to the rule to say that it has to do with issues that are in dispute. The court has gone on a recess, like our viewers saw, and they'll be back shortly. They are going to confirm, they'll come back with their decision.
Joseph, explain to us what happened at the very beginning of this proceeding. What were the rules explained? Is this the pre-trial that has been talked about?
No, the pre-trial itself is still yet to commence. And so once the case was called, the court did notice that, in fact, the court said it came in late because of the outstanding issues that had come to its attention, because just yesterday it had received some documents that had been filed, including this application for interrogatories. And so the court was saying that it felt that it's important that it deals with those issues. And so that was what it started with, and those were the matters that it drew Mr. Chikata's attention. And Mr. Chikata was making a point that, the other application just is a request for admission of facts. And so it's not really a motion in the strict sense. But what is actually the issue that they want the court to deal with is the application to serve the Electoral Commission with a set of questions to have them answer those questions. And so that is what they drew the court's attention that the court should deal with. And the court then proceeded to have the argument with regards to that particular issue.
On the issue of admission of facts, has that been argued out?
No, that has not been argued out yet. And so the court commenced by dealing with the interrogatories, which is what has been arguing in the last 30 or so minutes. And so that is what the court dealt with. Mr. Chikata drew the court's attention that the other request simply relates to requesting for facts, which is not of urgent nature and which can be dealt with later on. But this particular one are a series of questions that they want the EC to answer. And so they ask that the court deals with that one first.
And also confirm we see 7 judges, so nothing has changed from last week.
Nothing has changed. The panel is the same as the other panel. The last time it has Kwesi Eninebo, Chief Justice, presided, and also flanked by Justice Yao on its right, and has Justice Mafusau on the immediate left. Then on Justice Yao's right, Justice Mariambo, and on the far left, we have Justice Agetro Tokonu also being there. And so this is the same 7-member panel that heard the case the other time.
Did they give further directions to how the proceedings would be, what we should expect after today, before they started hearing this case today?
We are expecting those further indications to come in once the court decides on this important matter of the answers, because if the answers are going to be supplied, it will have an impact on the case. And the petitioner holds the view that if those answers are provided, he believes it helps the case travel faster, but the EC obviously disagrees. And so once the court comes out with a decision, it will decide or determine the next line of action.
The affidavit in opposition by the Electoral Commission, the first respondent in this case that Chachikata refers to, is it one that you've seen?
Yes, I've seen a copy of that affidavit. Essentially makes the point that the questions they are asking are questions that answers can either be found in Mr. Mohammed's petition, or the Electoral Commission answers, or the answer provided by Nana Dankwa Akufo-Addo. And so they make the point that the other questions that don't have answers are because they are not matters that have been stated in the petition as going to be raised. And so they make the point that no one in the petition doesn't say that NCA helped in the transmission of results that affected the results as were declared. And so they are saying that, yes, that question is being sneaked through the interrogatory to be asked. And so they make the point that all the questions they are asking, they are not in dispute. The EC has actually admitted and pleaded facts in their responses to those issues. And so if they have any issue of concern, they should directly be speaking to the points relating to the other matters. And if they have the chance during cross-examination, they can tender in any other issue they have or any other questions they want to put across, and not seek to rely on this process to serving other matters that are actually not in dispute. And so they make the point that this process is allowed by law, but it ought to be matters that the other side, in responding to the petition, have disagreed with you on. And so in which case, you then now file after questions, then the court will have him or the other person answer it, then it puts the matter to rest, and you know how to proceed from there.
You know, Joseph, it's quite difficult to identify the judges because we can't see their faces clearly, obviously because of the mask and the distance from where they are and the camera position. But earlier when Mr. Chikata was arguing out the motion for leave to serve interrogatories and he was going through the questions where he specifically mentions Jean Mensah, there was one of the judges who was asking him to restrict that to the chairperson, as any of the officers at the Electoral Commission, any of the deputies could step in if she wasn't available. Which judge was that?
It was Justice Nene Amegata. He was the one who was engaged in that banter with Mr. Chikata about the fact that he holds the view that he was personalizing the position and making constant reference to the name of the chairperson. But the point that Mr. Chikata made was that the rules and the issues that they are raising questions to are functions that only the chairperson of the Electoral Commission, as the returning officer for this particular election, can speak to. And so that is why they mentioned the name. It's not the case that they are personalizing it, but they are mentioning the name because that is her role, and she's the only one who can perform that role as allowed by law.
The issue of whether or not what Mr. Chikata is seeking to do, which is the leave to serve interrogatories, is one that's a strategy by Mr. John Mahama's team to delay the trial, also came up directly in the response by the Electoral Commission. Explain exactly what they said in the response, and then also tell us about what Mr. Chikata said.
And so they make the point that this is a request that you are making that you have answers to already. And so one, you are now coming to argue that request. That takes time. Number two, if the court decides that, okay, look, even though the issues have been answered, still answer it anyway, it means they'll have to now take a date for them to answer those issues. Then they don't know what steps they will even take post having those answers to raise issues about some of the material facts and say they disagree with it, among others. Their point is that the rules are clear. You have filed your petition. If you want to make any additions, you can't make additions that substantively affect your case. Let's move on with the trial. Let's decide how the trial is proceeding. Let's call your witnesses to come and testify. And once they come in to testify, the case proceeds. Why do you want us to answer questions that you already have the answers to? Mr. Chikata's response was to the effect that in the 2012-2013 petition, there was a similar request that came in, and he was making the point that the court, even in ruling on the request for further and better particulars, did make the point that there were such other requests like the interrogatories that are quite important to this particular matter. So he argues that he does not think that those matters have been answered. And in fact, if indeed the EC admits that has already answered them, then they should just simply answer the questions yet again, because if you say that you've answered them, it shows how important those matters are. And he says we are not asking them to tell them what is done in law. We are not asking you to tell them that the law says the returning officer takes the results from here and takes it here and that. He said, no, we want you to tell us on oath what actually happened on December 7th and after December 7th. And so they don't see why they are saying that those issues are matters that are not in this. They relate to material facts about things that happened, which he expects them to be able to directly answer.
So as the court is on recess now, explain what's happening in the courtroom. Or what's happening?
The lawyers are basically on their feet interacting with each other. The parties that are in the court are also seated, some are interacting with others, and we expect that between some 15, maximum 20 minutes, the judges will come out and speak.
We know that there's a lot of security at the Supreme Court, the premises of the Supreme Court, but take us through what exists by way of security arrangement. Quite
heavy. So right from the main entrance of the Supreme Court premises, you have a crowd control vehicle parked there. There are some police bikers, about 8 of them, who are stationed on different entrance points. When you enter the premises itself, there's a barricade. We are not using the actual entrance to the Supreme Court. We're actually using the right wing side, where you go to a security check. Then you now go on your left, where there's another security check, where they have to ensure that you have an accreditation. There's an accreditation that entitles you to the compound, and it's another that entitles you to the courtroom. And so all those checks are done. Then before you enter the courtroom, there is a scanning that is carried out where your phones are taken and kept for you before you are allowed into the courtroom proper.
Joseph Akable is my colleague in court for us this morning, reporting on the election petition here. And this is the second time that we're seeing this case go on. What is to come really is the case management, the pre-trial conference in the form of case management, where the court will give specific directions as to how this hearing would go. But the first matter that it's been dealing with is this leave to serve interrogatories, and they've spent quite a bit of time arguing out on this matter. We've seen lead counsel for Mr. Mahama make a strong point for the court to grant leave to serve interrogatories. We've seen the Electoral Commission legal counsel also tell the court not to, backing it out with some law there. And of course, we've seen the counsel for Nana Addo Dankwa Akufo-Addo, who is an interested party in this matter, because if this is granted, we won't find anybody from that camp coming in to answer questions directly, as this is all towards the Electoral Commission and specifically the Electoral Commission chairperson. Court is on recess. Hopefully they come back to give their decision on this matter that has just come up. There's also a matter of admission of some facts that John Dramani Mahama's lawyers are also raising. Joseph Akabley is still on with us. And Joseph, you explained that this recess is probably going to take about 20 minutes. We've done a bit of that time. But do we know when the hearing itself will end today? Did they give time to the hearing today? Okay, I'm afraid we've lost Joseph Akabley, but it looks like the judges are back to make a decision on this matter, so we'll take you back into the courtroom. This is the 2020 petition hearing, a petition that seeks to overturn the result as declared on the 9th of December by Jean Mensah, chairperson of the Electoral Commission, making Nana Addo Dankwa Akufo-Addo then president-elect of the country.